Hey, and welcome to Making Law Simple. My name is David Helma, licensed practicing attorney, although being in a treehouse in the state of Michigan. Welcome, everybody. Welcome. We have some Crumbley updates to bring to you today. I know it's been a while, but we have some motions that were filed. We have some motions we didn't know about, and we have some deals we didn't know about. So we're going to talk about it all as much as we can. I've got a couple of hours tonight, and we'll see how much we get through. This might be a two-parter. I was just sitting up here finalizing everything, thinking this might be a two-parter. But hey, Fox, welcome. Half Irish is here. Angela is here. We've got Vodka Blood. Jung is back from the dead. Welcome back, Jung. Got Jessica, who said that they're still convicted Crumbleys. Mavica. All right. Well, you know, you're only one of 12, right? So that doesn't meet the standard. Hey, Murphs, welcome. I'll play with our emotions. Yeah. No, we have a lot to go through. So I woke up on the morning of December 2nd to the news that Jennifer filed her appeal. Let's get her appeal. We have an appeal. Jennifer Crumbley filed an appeal. And the news media was reporting it the same way. I turned the TV on, and the news media is Jennifer Crumbley files appeal, throws lawyer under the bus. And it wasn't an appeal, folks. It wasn't an appeal. She filed a motion in the circuit court, the same one that convicted her. And that is not an appeal. So I don't know why everyone was reporting it as an appeal. The other thing we have, too, is a decision by the Oakland County Circuit Court with regard to a lawsuit where the school district is suing their insurance company regarding the civil action that's being brought against them. And it was being touted as sort of a victory for the families of the school district, and I don't really think it is. So we're going to go through that as well. And yeah, right. I'm shocked. MLS woke up. I'm shocked. Wendy H. Hey. I'm not in chat, just listening. Well, I think you are in chat, Wendy, but we're glad for you to be here, however you are. Oh, yes, I have been demonetized again. Yes, I have. So I put the Cash App up again. If anyone is so inclined, no obligation necessary. I bring this out to you for free, but donations, of course, are accepted, like any prostitute would say. So feel free to donate to the cause if you are so willing. But yeah, I was monetized for like a whole 3 weeks again, and then they took it away again. So we're having fun dealing with that. Hey, Nosy, good to see you as well. Cindy Lou Hoot, welcome. I was hoping this was covered. Yeah, well, we're going to cover it. Look at that. I am streaming, by the way, on X as well as Rumble, Facebook, 2 different Facebooks. I'm streaming everywhere today. And because YouTube keeps demonetizing me, this might be my last ever stream on YouTube. We'll see how it goes. But I think I'm going to dump YouTube. I think I'm going to stick with X, Facebook, and Rumble. So go find me over there, because what's the point of streaming on YouTube trying to make money at it when you can't? What did I do this time? I blame Salvador or Ilya. I blame him. I've been putting a lot of clips of his stuff up, and YouTube said that I don't have enough of my own original content. So apparently I'm not streaming enough of my own stuff. And yeah, I didn't make anybody mad. That's what it was. So it was after like 3 posts of clips from Ilya and Excited Utterance. Retiring again. Just changing platforms. Yeah, definitely. Dolly struck me. All right. So let's get into this. We have a lot to read. This is going to get kind of intense. So, but let me set the stage if you guys don't know. So in November of 2021, Ethan Crumbley shot up the Oakland or Oxford school, excuse me, Oxford High School. Killed 4 people. I think he injured 7 more. And didn't take his own life. And so he was arrested, and then his parents were subsequently arrested, and they were charged with involuntary manslaughter under 2 theories, 2 possible theories. One, they failed to take action to intervene on with their son, knowing that he was a danger, and 2, they failed to secure the firearm and that they had in their home. Jennifer was convicted in February. James, her husband, was convicted in March of 2024. Yeah, this past year. And so now, obviously, they're in the appellate process. Now, I think this motion that we're going to go over was brought by her appellate attorneys because, for one reason, very specific reason, several of the issues raised in this motion, I don't think were raised at the trial level, right? So in order for you to raise an issue at the appellate level, you have to have preserved it at the trial court level. Now, on December 2nd, or right around there, a few days afterwards, I think, Jennifer's appellate brief was due. It was to be filed with the Court of Appeals. I checked with the Court of Appeals after everyone woke me up saying she filed an appeal. They didn't have it. It wasn't filed. Instead, what was filed was this motion at the circuit court. And it raises issues that were never raised by her original attorney, Shannon. Now, I did reach out to Shannon. I emailed back and forth a little bit. She shared this motion with me. I asked her if she wanted to come on and answer some questions. She said no, thank you. That she had dinner plans. I asked her if she wanted me to make a statement or anything like that. And she did not get back to me. So I don't think any statements will be forthcoming from Shannon, which is probably appropriate because it's still in the court system, and she's also kind of being thrown under the bus a little bit. What's she going to say? No, I did a great job. You kind of step aside at that point and want to just sort of be quiet about things. I always say you don't want your trial attorney doing your appeal, because one of the things that you lose the opportunity to do is to throw your trial attorney under the bus. They're not going to do that if it's themselves. So you always want a different attorney doing your appeal. And if you're the trial attorney and the appellate attorney says you did a horrible job in their brief, you just sort of let it go, because you're trying to do what's best for your client. And if what's best for your client is throwing yourself under the bus, you do that. Let's see here. By the way, I don't know. I have some mods. Look at that. Stray. Welcome. Both theories stank worse than her lawyer. Yes, they did. And since you can't super chat me to get my attention, that's okay. I've never needed that, but throw a red question mark in the chat if you really have a question that you want me to answer. And if I don't get to your question because I missed it and I didn't scroll up far enough, throw it in again. The mods aren't going to get mad. It's not going to seem as spammy. They know the routine. I'll try to get your questions as much as I can. You didn't miss anything, beautiful waterfall. Just me killing some time waiting for people to get here. Yes, the swinger bisexual is here. Hey, Daddy's Belt. I see Daddy's Belt in the chat all the time. Not in the chat. I see him in my comment section. But welcome to a live, sir. This is your first live, I believe. You thought she did well? I thought she did well until she broke out the Taylor Swift lyrics, which was her first words to the jury. So, yeah, that's how well I thought she did. Now, she did okay. I think there could have been... she didn't present the case the way I would have presented it, but that doesn't mean it was necessarily bad. It was just not what I would have done. And Ghost is making a round. She's back to YouTube. If you're giving up anyways, can I be? Yeah, you know what? Yes, you can. Yes, you can. Let's see here. Add as moderator. Fox is now a moderator. There we go. Ghost, you'll never be. Sorry. All right, but let's bring this up. All right, so this is what was filed on December 2nd. This is just a few days before the appeal brief was due. This is not the appellate brief. You can see it right here. It says in the circuit court for Oakland County. I don't know why the media talked about it being an appellate brief. January 8th at 8:30 a.m., there is going to be a hearing on this. Now, I will be in Sweden, but I am going to do everything in my power to be able to present this to you and bring the hearing live if I can. So I just wanted to point that out. I don't know how that's going to work, just with timing and everything. All right. So this is essentially what this is. This is the motion, and then the rest of it's the brief. And it's the brief that's the interesting part. So this is Defendant Jennifer Crumbley's motion for judgment of acquittal and or for a new trial and or request for evidentiary hearing. So that's what was filed. So it says on February 6, 2024. It was 2024. I was right. Jury found defendant Jennifer Crumbley guilty on 4 counts of involuntary manslaughter arising from the shooting that occurred on November 30th, 2021 in Oxford High School. Ms. Crumbley's son, who is charged as an adult, pled guilty to the murders and was ultimately sentenced to life in prison without the possibility of parole. The prosecution proceeded on 2 separate theories of criminal liability for involuntary manslaughter. That Mrs. Crumbley acted grossly negligent in storing a firearm and ammunition so as to allow her minor child to access the gun, or alternatively, that she was grossly negligent in failing to control her minor child so as to prevent him from intentionally harming others. Those were taken straight from the jury instructions. I remember that clearly. By the way, if you guys didn't watch the trial, I do have an entire playlist, and it is linked in the description below, of Jennifer's trial. I am still uploading. I didn't realize I didn't upload to this channel the Miller hearing for Ethan Crumbley or James Crumbley's trial. So I'm going to get to those. But Jennifer Crumbley's trial is up. Quite a catch 22 with a super chat or without. Yeah, I know. Yes, it is. Yes, it is. I don't have to read it. And I don't have to read members' names when they're gifted anymore. So at trial, the prosecution offered the testimony of 2 school officials. Sean Hopkins, he was the squirrely little counselor. A counselor at Oxford High School. They don't say squirrely. And Nick Ajax, the dean of students at Oxford at the time of the shooting. Hopkins and Ajax were the last 2 school officials to interact with the shooter and his parents hours before the shooting took place. Relative to the prosecutor's 2 alternative theories of criminal liability for involuntary manslaughter, the court instructed the jury that it's not necessary that you all agree on which theory has been proven, as long as you all agree that the prosecutor proved at least one of these beyond a reasonable doubt. So half the jury could say that she failed to store the firearms, and the other half says that she was grossly negligent for failing to control her minor child, and it's still a conviction. That was the jury instruction. That was page 16. On the second day of deliberation, the jury returned a guilty verdict on all the 4 counts. Don't forget to bully that like button. Yes, and odd numbers, ideally. Thank you very much, Fox. After the trial concluded, it came to light that the prosecutor had entered into a proffer agreement with both Hopkins and Ajax. See Exhibit A. Now, what's interesting is I follow a guy on YouTube, or not YouTube, on Facebook. I want to pull this up. So this, by the way, this is Hopkins. This is the school counselor. So on October 22nd, Metro Detroit Crime Report, and I did link his Facebook page in the description as well. He wrote this article, and I found this very interesting. I shared it on Facebook, but I thought, oh, this isn't really going to kind of go anywhere because this is more school related. But in the morning hours of December 8, 2023, the now former high school counselor, Sean Hopkins, made a deal with Oxford's community schools. Nearly a year earlier, he made a secret agreement with the Oakland County Prosecutor's Office for immunity in exchange for his testimony against the Crumbley parents. So Metro Detroit Crime Report has obtained an exclusive document that shows Sean Hopkins, the last person to see Ethan Crumbley before he went on his rampage that resulted in the deaths of 4 students and injured 7 others, made a deal with Oxford School District weeks before the trial of Jennifer and James Crumbley was set to begin. A deal that would see Sean make over $45,000 for his testimony against the parents while he stayed on the payroll at Oxford Community Schools. According to the document, Sean offered his resignation to the school district in December of 2023, before the trial of Jennifer Crumbley was set to begin in January of 2024. But the district had other things in mind. They didn't want to accept his resignation. They wanted to keep Hopkins on the payroll through the trial of James and Jennifer Crumbley, and they ponied up to 9 months of salary to pay him to sit at home. Documents show the signature of Sean Hopkins and then Vicky, whatever, the acting school superintendent. The union representative, James Gibson, signed off on the agreement on December 8, 2023, signaling the union and the district negotiated the settlement. The details of this agreement are both alarming and quite frankly eye-opening as of the timing of the deal. The agreement named a signed resignation agreement is listed as confidential and outlines the terms of what the district was to pay Hopkins. Hopkins was to stay on paid administrative leave until August 15th of 2024, collecting his biweekly salary. The district also agreed to pay his health insurance through August 31st. The secret agreement included Hopkins' signed resignation, which, as mentioned, was dated December 8, 2023, but was not to become effective until the previous mentioned date of August 15th. So basically, he's getting paid to stay at home while he's testifying in this case. So now there's more to this guy, by the way. There's more to this whole thing. So that's just the agreement with the school district, okay? The school district says, hey, you want to resign? That's fine. We don't want you to. Tell you what, we'll keep you on the payroll for 9 months and you just stay at home. You don't have to do anything. Just stay at home, but you're on the payroll for 9 months. So I saw this and I was like, okay, it's kind of a sweetheart deal against the school district. I thought it might have something to do with the school district's liability and blah, blah, blah. Didn't think much of it. As we get into this, it's going to become more clear as to what exactly was going on. Who found the resignation letter? So, Jung, this is Metro Detroit Crime Report on Facebook. You can check them out. And he has a lot of stuff that they've been reporting on this. And he's the one that got this initially on October 22nd and wrote this article that I had just shared. Didn't think much of it at the time. So after the trial concluded, it came to light that the prosecutor had entered into a proffer agreement with both Hopkins and EJAC. So this guy, not only does he get a sweetheart deal from the school district, he also gets a deal from the prosecutor. And they're attached as exhibits, although I don't have them with this motion. I wanted to see them. I could get them from the court. I thought they were attached and they're not. And it is what it is. As expressly set forth in this agreement, the purpose of the proffer agreement was as follows: to receive truthful information from your client, the counselor, including information about possible criminal activity by your client, the counselor, and offers, and to evaluate your client's credibility as a source of information and potential witness. In return, this office will consider your client's proffer statement in deciding how to resolve this investigation as it relates to your client and any charges pending against your client being prosecuted by the office. So what they're saying here is you're going to agree to testify favorably for the state, and in so doing, we will reevaluate any potential criminal charges against you, Mr. Counselor. Despite defense counsel's formal written discovery demand dated December 6, 2021, neither of these proffer agreements nor the recorded proffer interview statements were ever provided to the defense before or during the trial. Yes, that's exactly what happened. Yes. Oh, how do you say prosecution? Anyways, on March 20th, 2024, the prosecutor's office issued a press release indicating that it has received multiple requests for copies of the two proffer agreements provided to Nick Ejax and Sean Hopkins, and further stated, given the ongoing speculation surrounding the proffer agreements, it is in the interest of transparency that the office is releasing this agreement. March 20th, 2024. This is after both, but definitely Jennifer. When was James? James was convicted after this or before March 20th, I believe, as well. But this is all about Jennifer, so they're only going to focus on her, not James. Mrs. Crumbley now moves this court for entry of a judgment of acquittal or, in the alternative, a new trial based on the following issues. So this is all the issues that are set out in this motion. The defendant is entitled to judgment of acquittal based on the prosecutor's discovery violation under MCR 6.201, which is essentially the Brady rule that's codified in our court rules. That defendant is entitled to a new trial based on the prosecutor's deliberate suppression of impeachment evidence relating to two prosecutorial witnesses. The defendant's right to due process and a fair trial. Sorry, my phone's going off. And a fair trial were violated by the prosecutor's assertion of inconsistent theories of culpability. That one's going to get interesting when we get to it. That the defendant owed no legal duty to the victims of the shooting, such that she could not be held criminally responsible for involuntary manslaughter. That's what I've been saying. The defendant's constitutional rights were violated by the court's instruction to the jury that they convict the defendant in the absence of a unanimous agreement. That one's a little iffier because Michigan hasn't really dealt with that yet, that I'm aware of anyways. Ineffective assistance of counsel is number 6. So again, that's why you have a different appellate attorney. Yeah, no, that was me vibrating. All right. So the court should grant the defendant's judgment of acquittal based on the prosecutor's suppression of proffer agreements with two of its key witnesses. This kid had to have shown insane behavior prior to the school shooting. He didn't really, though. Based on all the testimony, I mean, he really didn't. He had a couple of weird things, but not really much. He wrote on some math test. That was like, and that was the day before. A week before, or a couple of days before, he was looking up bullets on his phone at school, but nobody thought that was weird. The school officials didn't even think that was weird, based on their messages that they left James and Jennifer. So Michigan case law recognizes this court's power to dismiss the defendant's criminal charges based on discovery and or a Brady violation. If granting a continuance would not serve to protect the above interest, only then should the trial court utilize other more severe remedies. More recently, our Court of Appeals has affirmed the remedy of dismissal based on discovery violations committed by the prosecution. The case Causey makes clear that the defendant need not succeed in proving a Brady violation before seeking a remedy of dismissal under MCR 6.201J based on the prosecutor's failure to turn over exculpatory evidence. The prosecutor was duty-bound under that rule to produce not only the proffer agreements it entered into with both Hopkins and Ejax, but also their record proffered interviewed statements. Prosecutor's duty under this rule was expressly triggered when the defendant made a formal written request for discovery. MCR 6.201B provides as follows. Upon request, the prosecuting attorney must provide each defendant any exculpatory information known to the prosecutor's attorney, and 5, any plea agreements, grants of immunity, or other agreements for testimony in connection with the case. It's pretty clear that that's exactly what was being asked for, and that's exactly what this is, and that they should have turned it over. And you say clearly his parents weren't paying any attention. Well, maybe not. Kids do a lot of things that their parents aren't necessarily aware of. And it's not because of lack of paying attention. It's because of kids have a tendency to hide things from their parents. In a press release issued March 2024, the prosecution asserted erroneously that they had no duty to produce the proffer agreements because the agreements did not confer immunity. Prosecutor's assertion, however, is belied by the plain language of the rule, which requires the prosecution or which requires the production of any other agreement for testimony in connection with this case. Yeah, it doesn't have to be immunity. It clearly says right here, or other agreements for testimony in connection with this case. Whether or not the proffer agreements conveyed immunity is entirely besides the point. The fact remains that the prosecution entered what can best be characterized as a cooperation agreement. Maybe. I think it's clear that they were saying, you do this and we're not going to prosecute you. In considering whether a dismissal of criminal charges is warranted for discovery violations, including the suppression of evidence, the trial court must balance the interest of the court, the public, and the parties in light of all the relevant circumstances, including the reason for noncompliance. Now, here's the thing, though. Here's the thing. The prosecution didn't have to do this. Yeah, right, Nick? Yeah, Alec Baldwin got off on all charges dismissed for this very issue, right? A woman died at his hand. At his hand. He pulled the trigger. And the case was dismissed because the state did not turn over documents that were in their possession. That's right on. Welcome, Nick. Welcome. And Josie made it. Welcome, Josie. Welcome. Welcome. No, he got off because of the state, not the ammo. He got off because the state was withholding evidence that should have been disclosed. That's exactly why the charges were dismissed against Baldwin. And I don't like Baldwin. I can't stand the guy. I think he's a condescending asshole, and I don't like his politics. But at the end of the day, I still like the ruling because that's how it should be. If the state violates these rules, the sanction should be severe because the state has all the power in the first place. In this particular case with Crumbleys, they didn't need to withhold this evidence. I would say, based on what the juror had to say, the jury foreman in Jennifer Crumbley's case, this wouldn't have mattered. This would not have mattered, and they still would have convicted Jennifer Crumbley, especially with the testimony that she gave on the stand. That being said, the state might have screwed themselves out of a fairly solid conviction, provided that the Supreme Court doesn't overturn this by saying we don't really like the way this slippery slope is going. But because they failed to comply with very simple rules. If you have information, you turn it over. That's it. Why play games? Why try to hide something? Why be so obstinate? We're going to get into a whole bunch of other issues too with the games that the prosecutor was playing here as we keep going. But if granting a continuance would not serve to protect, so what they're saying is that the default for the rule is that, you know, if it's before trial or in the middle of trial or when trial starts, like the morning of, hey, we got this new evidence, you know, the default is, all right, grant a continuance to allow everyone to deal with this new evidence, and then we'll continue. But if that's not practical, and it kind of isn't here, then more severe remedies such as a dismissal can be had. Yeah, state needs to play by the rules. It's that simple. I agree, Fox. In certain instances, like those presented in, I'm going to say Solomon, a continuance before or during a trial may be more appropriate remedy to address a late disclosure of exculpatory evidence. But here, the damage caused by this suppression of the withholding of the witnesses' cooperation agreements cannot be undone or cured. Hence, the court should grant a judgment of acquittal. I agree that that's the only way to cure it. Now, whether or not you agree with should they do it, was this really bad or not, that's a different story. But that's really the only way to cure it. If the court finds that this was a unlawful Brady violation, the only way to cure it is to set aside the conviction. The same is true for the public interest, which is best served by enforcing constitutional rights and imposing a penalty upon the prosecution for the violation of such rights. The prosecution, on the other hand, is the party responsible for violating the interests of both the court and the public by its deliberate withholding of favorable impeachment evidence. And it is favorable, regardless of what you guys want to say. Even I say it might not have worked, because I listened to Vampire Foreman Lady, and I don't think this impeachment evidence would have worked on her. Might have worked on a couple other jurors sitting on that case, but it might not have worked on her. Either way, it's potentially favorable impeachment evidence. Prosecutors' duty under Brady has been extended to include evidence that could be used to impeach prosecution witnesses. Failure to disclose impeachment evidence of consideration given evidence of consideration given in exchange for prosecutors' witnesses' testimony. Oh, they're citing a bunch of cases. Failure to disclose impeachment evidence indicating that the witness was a government informant. Failure to disclose 3 lines of impeachment evidence undermining state's 2 key witnesses. All of these cases is where the court said, yeah, this was a Brady violation. A new trial is required under Brady v. Giglio, where the undisclosed evidence creates a reasonable probability of a different outcome. And I would agree that it would create a reasonable probability of a different outcome. Hey, Luke. Okay, there's the name drop. Yeah, you guys forgot about Vampire Foreman Lady? She was great. If MLS was a judge, would you have dismissed the Baldwin case? I like to believe that I would have, but it wouldn't have been the first case that I've dismissed. I have been an attorney for 14 years practicing, going on 15. And the amount of times that the prosecutor in my criminal cases have tried to pull something on just nothing cases. Like, I don't know if I've given this example before. There was a domestic violence / child abuse case. The law on that, as far as bringing in priors, is very specific. If you're going to bring in prior acts of domestic violence or child abuse, you can only go back 10 years, and it has to actually be one of those 2 things, right? So despite the law that clearly says that, this is an exception to the prior bad act rule that's carved out in statute and court rule. The prosecutor wanted to bring in things from like 20 years ago, 30 years ago that weren't even child abuse or domestic violence or anything of that nature. And it's like, why would you send me a letter and send me past criminal conduct and say, I'm intending to introduce this? You know you can't. You know you can't. And now I have to go file a motion, and we have to go to court. And I have to drag your ass to court because you're trying to do something you know you cannot. You know you can't do this, right? So if I was a judge, and what I'm getting at is if I was a judge, I would imagine I would have thrown out more cases and evidence, and I would be off the bench so fast, I would have never made it to the Baldwin trial. Because, like it or not, at least in Michigan, judges are elected positions, and if you get a whole host of prosecutors against you, you're probably not going to stay on the bench long. Have more parents been charged with neglect now? So in between the Oxford school shooting and this trial, there was a new law passed, which is called the Safe Storage Act or Safe Storage Gun Act or something like that, which says that if you have a child in your home, anyone under 18 that lives in your home, you have to keep your gun in a locked safe with the ammunition separate from it and all these things like that. And so under that new statute, there have been 5 or 6 or So charges where children have shot children, or a gun was dropped and a child was shot, or things like that, or a child got its hands on a gun and just fired it. There's been 5 or 6 charges under that new statute, but nothing to this extent. Now, I say that there is a case in Grosse Pointe, which is in Macomb County, where a star athlete, high schooler, swimming athlete, was drunk and had 2 friends in his car, and he was speeding down the road and he hit a tree, and he survived and the 2 friends died, or at least one of them did. Now, what's interesting in that case, let me pull this down so I can talk about it a little bit. What's interesting in that case is that there's a push. You know what? I think the accident took place in Wayne County, because the Wayne County prosecutor, Kim Worthy, who has been here forever, and a lot of people don't like her. I find her to be she's like the queen of England, right? She's just a steady hand. You're going to have mayors and other politicians come and go, good judges, bad judges, and she's just a steady hand. For as long as I've been practicing and longer, she's been the Wayne County prosecutor. There's a push to have the mother of the driver charged criminally under the same theory that this case was brought, that the Crumbley case was brought. And the idea is that there was a text message sent from the mother to the son, like maybe, I don't know, a few months prior, that said, slow down, you're driving too fast. Apparently she had a app 360 or some way to monitor the son's driving. And then after that, she bought him like a souped up sports car. This is Grosse Pointe. This is the ritzy area. This is where Henry Ford lived. This is that high end area. All the wealthy people, the ones with dungeons and chains in their basements. Those kind of people. And so the theory is that because she knew of his inability to control his speed, and then on top of it bought him a super fast sports car, that she is criminally responsible in the same manner in which Jennifer Crumbley is. A Wayne County prosecutor has not brought those charges yet. I don't think she will, but there's a push by the parents of the friends that were in the car, and I don't remember if both died or just the one died. There's a push, and there's like a petition going around or something to have the parents of the driver charged criminally. Now, the driver is being charged criminally. He is absolutely going to be charged. But the question is whether or not his parents should be. So there we are. We're up to date on sort of the fallout a little bit as it is. Let me see if I can get anything up. Aaron Olivia is double timing to catch up. I've been right there with you. Would you bend Ghost over a bench and spank her if she misbehaves after you get voted out of your robe? What? I wish you could put that in a super chat, Brandon, but welcome, sir. You're throwing tomatoes. Why is everybody throwing tomatoes at me? I wasn't even looking at the chat. I don't know if he was drunk, actually, now that I say that. I don't want to slander him. I don't know that he was drunk. I think he was a scoof, like just being a kid and with a really stupid fast sports car. Oh, you're throwing tomatoes because I want to leave YouTube. I'm done with YouTube. They keep taking away my monetization. I'm going to go to Rumble, and I'll start streaming on Twitch more. You guys can go find me on Twitch. Actually, there. Hang on. I'm adding Twitch. I'm live on Twitch. Right? Yep. Okay, cool. I'm live on Twitch. All right, go find me on Twitch. Money is for chumps. Yeah, right. Yeah, it is. Well, I got to take the money from Brandon somehow. All right, I'm getting back to this. But that was a good question. Sorry for the tangent. Dungeons and chains in their basements. Okay, so in the same town where this kid was, maybe 6-7 years ago, there was a guy whose wife was unalived, and she was like, I don't know. Basically, he hired a hitman to take her out. He hired this guy who was a little slow. I don't know if he had closed head injury or something like that to take him out, or take her out rather. But he was known, I can't remember his last name, but he was known as like Master Bob because he had a dungeon in his basement and he would invite the neighbors over for like swinging parties. And he had like this sex dungeon in his basement. And that was the same area. So that's why I was talking about dungeons and chains and basements. You know, rich people with too much time on their hands. All right. Where was I? I got all distracted and flustered by rich dungeon basements. All right. So the question is not whether the defendant, Bob Bashara. All right. The question is not whether the defendant would more likely than not have received a different verdict with the evidence, but whether the evidence is whether in its absence he received a fair trial. Understood as a trial resulting in a verdict worthy of confidence, right? So that's what we want. That's what the courts look for, a verdict in confidence. The Sixth Circuit has granted relief on numerous cases where the prosecution failed to disclose cooperating agreements with prosecution witnesses. And then they go through and cite a bunch of cases. In addition, the federal court precedent, in addition to these federal precedents, Michigan law has long recognized the duty imposed on the prosecution to disclose both favorable and impeachment evidence. And then it goes on to cite a bunch of Michigan cases where trials were reversed and verdicts were set aside. Whether under federal law or state law, the test for reversal for the Brady violation asks whether the suppressed evidence might have affected the outcome of this trial. As such, the court must now consider whether this suppressed proffer agreements were both favorable and material, and they are both. I would agree that they are both. I do, Dirk. The proffer agreement could have been used by the defense to vigorously cross-examine and impeach both Hopkins and Ejax insofar as their witnesses provided key inculpatory testimony against Ms. Crumbley. And I agree that their testimonies were fairly key. But it's funny, this attorney points out some things that the prosecutor might not have favored their testimony. Had defense counsel had the proffer agreements, she could have brought to the jury's attention that these witnesses had motive bias and a personal interest in help the prosecution secure Ms. Crumbley's conviction. And I believe that line of argument was open already, but the court didn't allow it because the line of inquiry would have been more so you're protecting the school in a civil lawsuit by your testimony, which is unrelated. But a proffer agreement for the very case itself is different. That would have been allowed. These witnesses were in the proverbial hot seat, hoping to avoid criminal prosecution of their acts and omissions related to the shooting. Yeah, that's why that proffer agreement would have been very nice to have. Furthermore, the prosecution has suggested that in its press release that there was never an implicit or explicit promise of leniency or favoritism of any kind. Such an assertion is contradicted by the express terms of the agreement. In fact, the proffer agreement expressly provides that in return for cooperating and providing truthful information, including information about possible criminal activity by your client and others, this office will consider your client's proffered statements in deciding how to resolve this investigation as it relates to your client and any charges pending against your client being prosecuted by this office. This office will not offer any proffer statements made by you or your client in this office's case in chief in any criminal prosecution of your client. So that last part. So anything that they said on the stand would not be used against them if the state or if the prosecutor's office decided to bring charges against them. That's the part that makes this, and also the fact that they're going to use their testimony and considering whether or not they prosecute them at all, how they resolve the case, right? Wink, wink. I'm not telling you what to say, but if it's favorable testimony and truthful testimony, then, we'll take that into consideration. Twitch link. The Twitch link should be in my my link tree. Let me find my link tree. Does everyone have my link tree? I don't know if Jung has it anymore. Let me find my link tree. Log in. I'll put it in the chat here in a second. Yeah, it's there. Okay. Share. Copy. Oh, thank you, Half Irish. Well, I'll still put it in anyways. All right, so there's my link tree, Half Irish. I already posted it in the chat on YouTube. If you guys want to go watch on Twitch, I haven't streamed there in a minute. But yeah, I'll be streaming somewhere. For the prosecution to now claim that there was never an implicit or explicit promise of leniency or favoritism of any kind is simply disingenuous at best and deliberately misleading at worst. I would lean towards the deliberately misleading part. Let's see. It's an axiomatic that the credibility of the witnesses in issue of the utmost importance in every case. Oh my God. It is axiomatic that the credibility of the witnesses is an issue of utmost importance. That's a horrible way to say that. In every case, it is also as you have a due process right to challenge the witnesses. There we go. It's very important. The credibility of the witnesses. The defendant is entitled to have the jury consider any fact which might have influenced the witness's testimony. I actually argued this in an appellate case just recently myself. Having deprived the jury of such material evidence results in the denial of Ms. Crumbley's constitutional right to due process and a fair trial. On this point, the jury heard that neither Hopkins nor Ejac told the Crumbleys during their meeting that they had to remove their son from the school, despite their purported mental health concerns. Remember, they said, no, you didn't have to remove him, but we do have concerns. So Hopkins testified that the drawing also gave me a lot of concerns about suicide. So that's Hopkins. Hopkins also testified that it was his professional judgment that it would be better for the shooter to be around his peers who are his age than to be home alone. And then Ejax, on the other hand, testified that he would have searched the shooter's backpack that contained the gun if there had been any type of indicator that the student was going to be a threat to anybody, including himself. I know, Fubar. I know. YouTube is like, we'll figure it out. We'll brainstorm at some point on what we're going to do here going forward. Given the inherent conflict between Hopkins and Ejac's testimony, the jury had to decide who, if any, to believe as far as whether the shooter posed a foreseeable risk of harm to himself or others. Remember, there has to be some sort of foreseeability. I think somebody in the chat that believes, is it Mavica, that believes that Jennifer is still guilty. You still have to have foreseeability. Yeah, right? YouTube can jump up and kiss my white ass. And on the other platforms, I won't have to censor myself either. Finding itself unhappy with some of Hopkins and Ejac's testimony, the prosecutor on redirect sought to shore up its case by eliciting additional testimony more favorable to the prosecution. And there's a footnote here. And it says, this is a quote from the prosecutor. I'm not going to tell you that I liked everything that Hopkins and Ejac testified to. I'm not going to tell you that I think it was okay they didn't look in the backpack. I don't think it was. This was during her closing arguments. So she clearly wasn't happy with their testimony. in the first place. So surprised charges aren't being brought. For example, Hopkins was asked if he would have responded differently if he had known that the shooter had sent some text messages to his mom 8 months before the shooting. 8 months, right? First of all, then you're also asking a hypothetical situation, which shouldn't have been asked, about what he believed were abnormal occurrences at home. To these questions, Hopkins responded that had he known, he would have handled the November 30th, 2021 meeting differently. Putting aside the incredulous nature of Hopkins' testimony on redirect, the jury should have been made aware that Hopkins had a bias, motive, and personal interest. He absolutely had a personal interest in his testimony. A cooperative post-shooting investigation report prepared by Guides Post, Solutions, LLC, lays bare the culpability of both Hopkins and Ejax. I'm not going to go through all this. Actually, I'll go ahead and throw this in the Discord if you guys want to read it later. But basically, it says like those two guys dropped the ball. It quotes a bunch of sections, but those two guys dropped the ball. If the school decided to let him stay, as it did, then the shooter and his bag should have been searched. That was essentially their conclusion. The point of highlighting these investigative findings is not to prove the criminal responsibility of Hopkins and Ejax. Rather, these findings merely demonstrate why Hopkins and Ejax were given proffer agreements in the first place, because they had obvious criminal exposure. To the extent that these witnesses testified so as to shift the blame away from themselves and onto the parents, the jury should have been made aware of these proffered agreements so that they could have more accurately and fully assessed the credibility. Now, I have from the trial stream itself. This is a funny part. Now, the audio did skip a touch from the original broadcast, and I'm not sure why, but I wanted to play this again real quick. So we're Mo, myself, and Legally Live are sort of frustrated with the fact that the audio skipped, but just listen to what the prosecutor has to say. That's why you should get quality cameras in the courtroom, like Mickey Mouse simple cameras.
Yes.
That this is not an argument, but this is about Jennifer Crumbley's actions. And any attempt to make it about what these two individuals did or didn't do, like it or not, who did not have any of the information that was so jarring, it's about what she knew and what she didn't say.
So what's funny is that
Sean Hopkins.
What's funny is that they tried to use these guys for their testimony, and then it backfired a little bit, and they started putting the defense started putting the idea that the school really failed and not Jennifer in the minds of the prosecutor at the very least, because she spent a lot of time talking about these two guys, about Hopkins and Ejax, and during her closing argument. And the fact that this proffered agreement wasn't presented is a huge issue, just because of the amount of time that everyone spent talking about them. Maybe. I was there in the courtroom for some of it. No, James's was completely different. Actually, I thought James had a much better case than Jennifer. I was really thinking that James might have been acquitted. All right. At this point, it should be noted that the court provided the jury with a preliminary instruction. Oh, wait, hang on. Wait, yeah. Sorry, I didn't miss anything that I didn't want to say. Instruction to consider whether the witness has any bias or prejudice or any personal interest in how this case is decided. This was a jury instruction at the onset of the case. Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does this witness have any special reason to tell the truth or any special reason to lie? And then the court re-instructed the jury at the end of the case, right before deliberations. One of the elementary principles of cross-examination is that the party has the right to cross-examine, has a right to draw out from the witness and lay before the jury anything tending to affect the credibility of the witness. And I actually cited this case in one of my appeals that I just filed last week. It's a very important right to be able to cross-examine and impeach the credibility of a witness, especially if they have, it's right there in the jury instruction. This is the jury instructions as they're written and as they were presented in this case. So very important to have that. The prosecution denied the defendant's right to due process by asserting inconsistent theories insofar as the prosecution charged the shooter as an adult, but at the same time charged the defendant for failing to control their minor child. We might have met Mavica during the trial. That's right. The court should grant judgment of acquittal based on the violation of Ms. Crumbley's due process rights caused by the prosecution's assertion of inconsistent theories of criminal liability arising from the same event. In particular, the prosecution charged Jennifer Crumbley's son, as an adult, and he was convicted and sentenced as an adult for the crime of murder. At the same time, the prosecutor's case against Ms. Crumbley was premised on its assertion that she failed to control her minor child, giving rise to involuntary manslaughter. These theories are both factually inconsistent and mutually exclusive, amounting to a violation of Ms. Crumbley's due process rights under both federal and state law. While Michigan has not yet adopted the position that due process is violated when the prosecution offers factually contrary theories during the prosecution of co-defendants, our appellate courts have cited federal case law establishing a federally secured prohibition on inconsistent prosecutorial theories of criminal liability. So Michigan federal courts have addressed it. Michigan state courts have not. This court and others have held that the due process guarantee is frustrated when the prosecutor uses contradictory theories to secure the conviction of two persons for the same crime. Then citing another case, it appears that due process was considered violated when mutually exclusive and factually contradictory theories were advanced against co-defendants charged with the exact same crime. Is that a drone moving across the screen? Yes, it is. Yes, absolutely it is. More recently, our Court of Appeals cited with approval the Eighth Circuit decision in Smith v. Gross, and held that the use of inherently factually contradictory theories violates the principles of due process, noting that such inconsistencies to constitute a due process violation must exist at the core of the prosecutor's case against the defendant for the same crime. In this instance, the core theory of criminal liability against Ms. Crumbley's is that she failed to control her minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. That was this specific jury instruction. While the prosecution argues that Mrs. Crumbley had a duty to prevent her minor child from harming others, the prosecution charged Mrs. Crumbley's son as an adult and argued that he planned the murders for months such that he should be held accountable as an adult, and argued for sentence to life without parole. The shooter cannot be needing a child for the purposes of Mrs. Crumbley's criminal liability, while at the same time treating him as an adult for the purposes of his own prosecution. These are mutually exclusive, factually contradictory theories of liability, which allowed the state to convict as many defendants as possible in a series of cases. Such blatant inconsistent theories of prosecution implicates the due process concerns raised by the court. During the shooter's Miller hearing, the prosecutor downplayed the allegations that her office was prosecuting the shooter and his parents under inconsistent theories. I streamed that as well. Will it play? Why won't you play?
He had many.
Can we talk
Play.
about big?
He plotted, he planned, he shows none of the mitigating factors and evidence that you see in hundreds of other juvenile life without parole cases. And I'm going to ask the court once again to rely on the testimony and the truth. The issue of what the school should have done or what somebody else should have done is not, it is not relevant, and it's not a mitigating factor. And blaming somebody else for not stopping a school shooter is for a different proceeding, but it is absolutely not an inconsistent.
That's when I go on my little tirade for a minute, because I saw this coming. It's not, it's for a different proceeding. Blaming somebody else for not stopping a school shooter is for a different proceeding. She wanted life without the possibility of parole for Ethan because he was an adult. He made a choice and there was no stopping him, is what she argued. And then she turned around in James and Jennifer Crumbley's trial and said they could have stopped him, and they failed to do so. I'm going to upload, by the way, the Miller hearing when I'm done with this. What time is it? I got an hour left. So I'm going to go for another hour. I'm only on page 18 of 37. This might be another, because we have a whole civil case that we need to deal with. This is a motion involving the school district and their insurance company, and I want to go over this with you. So this might be a two-parter, but I know I'm not going to be able to go on for hours and hours and hours today. So I might be coming at you tomorrow morning. Let's see here. Okay. So there has been a misconception that charging the defendant as an adult and charging his parents is somehow inconsistent. That is not true. They are charged for doing different things. This is what she said in the Miller hearing. That's part of what I just played you. That's not her exact quote, but that's what she argued. They're charged with doing different things. There's a problem with that. As one jurist aptly noted, the state cannot divide and conquer in this matter. Such actions reduce criminal trials to mere gamesmanship and rob them of their supposed purpose for the search of the truth. Here, the prosecution has charged 3 individuals for the same murders that were committed by Mr. Crumbley's son, or by Crumbley's son. The obvious inconsistency in the prosecution's theories is demonstrated by the fact that if they wished for the shooter to be viewed in the eyes of the law as an adult, or that they wish that. But as to the charges of involuntary manslaughter, the prosecution is arguing that Mrs. Crumbley is responsible for the same murders committed by her son because he was a minor child and she failed to control him. When the prosecution advances a position in the trial, or in the trial of one defendant, and then adopts an inconsistent position in the trial of another on the same facts, the prosecution is relying on a known falsity. Now, here's the problem with this argument, is that it's a great argument. It has not been recognized in Michigan state courts yet. The federal courts in Michigan have recognized this. Other state courts have also recognized this, but it has not been recognized in Michigan state courts. It needs to be, because it makes sense, right? Also, I don't like the idea of saying, well, you can convict her. You can, half of you can find her guilty of one and half of you can find her guilty of this other one. As long as you guys both agree that she's guilty of something, she's guilty. That one also has to be addressed by the state courts, which hasn't been yet. So what do we think will happen with this? So this is not an appeal, Beautiful Waterfall. I put that in the onset that everyone was reporting that Jennifer Crumbley filed her appeal. This is not her appeal. That's why I said the media got it wrong. This is not her appeal. This is a motion in the circuit court in front of the same judge. This is a motion to set it aside. Now, I believe the reason why the state, or not state, the defense appellate attorneys brought this motion in state court, or, oh my God. The The reason why I believe Jennifer Crumbley's appellate attorneys brought this action in the circuit court, in the trial court, and not in the Court of Appeals is because you need to preserve your arguments at the trial court level first. If you don't address them and preserve your objections and your appeal issues and all of that at the trial court, you lose the right to argue them on appeal. Very limited, very, very, very limited circumstances in which you can address something at the appellate court that you did not address at the trial court. So they brought this motion at the trial court level to preserve these issues, not because they think this is going to get granted by the trial court. This is not going to get granted by the trial court. She's going to summarily deny these. But this is what I think happened. If I'm projecting myself maybe a little bit in what's going on in the war room here of this law firm, is they're drafting these briefs, these appellate briefs, and they get to some of these issues, these particular issues. Then they're like, you know what? I don't think that these were properly brought before the trial court. I know this one wasn't because we just discovered it. And I know this other one wasn't because we just discovered it. But a few of these other things I know for sure weren't brought. Maybe we need to bolster some of these. This is written like an appellate brief. Okay, so this is very much written like an appellate brief. So this is the outline of their appellate brief. They convert it to a motion at the trial court level, and they file it, and now it's preserved. And they filed it before the deadline for their appeal. So, and I know that because I called the Court of Appeals when I heard that there was an appellate brief, and I called them and I said, hey, can I get a copy of that? Please send it over. And they're like, we don't have one. It was due today, but they haven't filed one. And I said, oh, then they must have filed something in the trial court. And that would delay the obligation to file the appellate brief that day, and then also address these things at the trial court level, which needs to happen first. So that's where we are, and that's what we're doing. But this is not an appeal. That's where the media got it wrong. That's the first place the media got it wrong. Second place was this issue, the civil case. And I want to address that, but that might be tomorrow. The inconsistencies then is that Miss Crumbley's son, who committed the murders, is being treated both as a child and as an adult for the purposes of the same murders. What's the footnote say? It is worth noting that at the conclusion of the shooter's Miller hearing, the court found that the prosecution had carried its burden of proof such that the shooter received a sentence of life without parole. The court could have only reached this conclusion based on its findings that the shooter acted with the willful capacity and intent to commit the murders such that he should be treated as an adult, which he was. In short, what the state claimed to be true in one case, it rejected in another case. And that's the problem. She was speaking out of both sides of her mouth. And I called it in real time. I said, she's going to argue this out of both sides of her mouth. And she did. The due process concerns arising from inconsistent prosecution theories is not tied exclusively to whether two or more persons are acting or charged with the exact same crime. While it may be the most common scenario, which under the courts have found due process violations, that is not the only instance that implicates the due process concerns. Rather, the court must look to whether the prosecution presents factually contradictory theories of liability against more than one individual arising from the same event. Okay, so this same event thing here, that's why I wanted to address this motion on the civil end, because what constitutes an event or an occurrence is a whole thing over here on this civil case. So stay tuned for that. Yeah, it does sound like it. And it was everyone, like I said, so I got messages on Discord and on Twitter saying, oh, she filed her appeal. She filed her appeal. And I'm looking at it. I'm like, that's not an appeal. And then I turned on the news, and the news was reporting that Jennifer Crumbley filed her appeal and threw her attorney under the bus and blah, 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 blah. It was nonsense. I am reading my Rumble chats. I'm reading them all. I'm not reading any chats, really. Sorry. When I'm reading a document like this, it's hard for me to also read the chat. So if you're over in Rumble, if you're on X, Facebook, YouTube or Twitch or whatever, and you want to chat, and you want me to actually read a question, make sure you put a red question mark in front of it. If you have those emojis available, it'll help me see it better. And then if I don't get to it and I miss it because I'm not reading them all, then put it again. Just keep reposting it until I eventually get it. But I'm trying to catch the chat as much as I can. It's not intentional. Yeah, like a red thing like this. It's a Moose Munch chocolate popcorn. Okay. That's the headline. I read it too. Yeah, I mean, that was the headline. She files an appeal, throws the lawyer under bus. Red question marks, exclamation point, something. Okay. Jung, you're surprised the media got it wrong? Yeah, they always get it wrong. All right. So despite the differing charges as between the shooter and his parents, the prosecution presented factually inconsistent, mutually exclusive theories during the separate proceedings. This inconsistency resulted in the denial of Ms. Crumbley's right to due process and a fair trial. Because this inconsistency cannot be cured, Ms. Crumbley is entitled to a judgment of acquittal. I guarantee this last sentence is going to say something different in the appellate brief, but it's essentially going to be the same argument. It's going to be this court should remand to the trial court with instructions to set aside the trial or set aside the conviction or whatever. All right, so Ms. Crumbley is entitled to judgment of acquittal because she owed no legal duty to the victims of her son's criminal acts. And in the absence of any such duty, she cannot be held criminally responsible for involuntary manslaughter. This is the one that I've been barking about since this charge was brought. What duty is owed? Because this is not a Seinfeld episode. You don't have a duty to protect somebody. You don't have a duty to act. There's no affirmative duty generally. There's no affirmative duty generally to protect somebody. Now, there are circumstances in which you put yourself in that position and create a duty. But they talk about it in here. But as a general rule, there is no duty. Let's see. MLS, if you get media access to Marcella, I'll take time off and attend as your correspondent. What is that? Access to Marcella? I don't know that case, but I'm down for it if I can get the time off. Okay, so if this gets shut down by the trial judge, will she then file an appeal? Absolutely, she will. She will she will file her appeal. So they already filed notice to leave to appeal, or not notice to leave to appeal, but a notice of appeal. And then the brief is due, I want to say it's like 52 days after. But if there's action in the lower court, you can get a stay and filing your brief until the lower court, the trial court, is fully resolved. And so that appeal is still pending out there, but they need a resolution on this first. And she absolutely will file her appeal. Will you be following the Georgia teen shooting case too? I don't know. I was looking at that, but my hours to stream, my time to stream is fairly limited as it is, as you guys can tell, with as active as my channel has been lately. So when it's cases like Crumbley or Zachariah Anderson, cases that I'm kind of invested in personally, like I feel like I have a personal investment in these cases, just because I don't have any personal stake in it, but I'm really interested in the outcome of those two cases. If it's outside of those two, I'll try to, but I can't guarantee. How you doing today? You know what? I woke up with a sore throat, and that's why I'm limiting myself to 2 hours. Because when I do these talking streams where I'm reading a lot, I notice my throat gets dry and hurts. But other than waking up with a sore throat, which I have no idea why, I'm doing good. Will you miss us when you leave too? No, Jojo, because you're gonna follow me to Rumble and Twitch and Facebook and X anyway. So you'll be right there with me. Yes, this is the correct question mark to use. Okay. I might have to start charging for these red question marks. Yeah. Yes. Yeah, that's an interesting case. So now, Excited Utterance and Salvador Dali have been streaming that. I was in the courtroom for her preliminary examination because I happened to be in court there for on another matter. And I was like, oh, let me just pop my head in. So when is that trial set for? I would love to cover that case. It's an interesting case. That's an interesting case. There's a lot of medical conditions. There's going to be a lot of medical testimony, and it's a truly heinous case. And I think the woman's just a complete drunk. But it's going to be kind of interesting to see if she tries to testify, because that's just going to be a disaster. Oh, you want to see? Okay, hang on. There we go. Now you can see me zooming around in the drone. Let's see here. Okay. Well, you guys are just chatting now with each other with question marks. Okay. Hang on. Well, that's not it. What did I do? There we go. By the way, I am going to be trying out new software. Nick Staroff is using new software. I think Dolly Talk did it earlier today. I can't remember what it's called. I've been setting it up, but I didn't have this stream set up with it. And trying to switch over without canceling my stream was a pain in the ass. So I decided not to use it today. But I will be. Probably, maybe even tomorrow. Because Ms. Crumbley owed no legal duty to the victims in this case, she cannot be held criminally responsible for involuntary manslaughter under Michigan law, such that the court should enter a judgment of acquittal. Footnote 6. It should be noted that in its prior opinion on leave granted in this case, People v. Crumbley, the Court of Appeals did not address, discuss, or opine as to whether Ms. Crumbley owed a legal duty upon which to find her criminally responsible. Instead, the panel, yeah, I know, they were like, wait and see. I will say the appellate courts are usually wait and see. Let's see what happens at the trial court before we address anything. Focus solely on the issue of the proximate causation, as that was the issue raised by counsel in the motion to quash. The issue of duty was neither raised nor addressed by the court. All right. So in order for there to be negligence of any sort, there must be a duty, a breach of that duty, the breach directly causing damages, proximate causation, and then, of course, damages, right? So you have to show those 5 things. So what they're talking about is in the Court of Appeals, they only dealt with causation, proximate causation. They didn't even deal with direct causation because that's usually there's direct causation. But they dealt with proximate causation and not the duty. Are you talking all the trolls with you? Or am I taking all the trolls with me to Twitch? Maybe. I tried to get an OnlyFans channel going too, but OnlyFans wouldn't validate my identity. I don't know. I sent in my driver's license so many times. I'm like, look, it's me. While the penalties for manslaughter are governed by statute, these elements of such offense derive from Michigan's common law. Under common law, a charge of involuntary manslaughter based on the omission to perform a legal duty encompasses the following elements. A legal duty. Capacity, means, and ability to perform that duty. Willful neglect or refusal to perform that legal duty, and the resulting death as a direct and immediate consequence of the defendant's failure to act. So that is what is required for involuntary manslaughter on sort of a general level. Let's go as grumpy. It's because I said I was leaving YouTube. Prosecution's theory of liability against Miss Crumbley was based on two theories: that the defendant was grossly negligent in storing a firearm and its ammunition so as to allow access to the firearm and ammunition by the minor child, or alternatively, that the defendant was grossly negligent in failing to perform a legal duty, that is, failure to exercise reasonable care to control her minor child so as to prevent him from intentionally harming others. That is a mouthful, but those are the two. As such, the viability of the prosecutor's case rests on whether Ms. Crumbley owed a legal duty to the victims of the shooting, right? We can all agree that there has to be a duty in order for there to be a cause of action. The prosecutor has thrice confirmed its position that she was proceeding under the theory that Ms. Crumbley had a legal duty to the victims of the shooting. That's key. The legal duty to the victims, not a legal duty to her son. A legal duty to the victims. First, during closing arguments, the prosecutor recognized that the prosecution had to prove that Ms. Crumbley had a legal duty to the victims. And again, during her closing rebuttal, the prosecutor stated, I have to prove that she had a legal duty to take care and protect the other children in the school. Okay? That is what she argued, and that was what she had to prove, and that is what she had to convince the jury, that Jennifer Crumbley had a legal duty to protect the other children in the school. Let's think about that. If you have kids in school, do you feel like you have a legal duty to protect those other kids in that school? If you do, great on you. But what does that look like in practice? I'm not acknowledging Zach until he super chats me. Then I'll pull him up. Additionally, during the shooter's Miller hearing, the prosecutor stated that Mrs. Crumbley had an obligation to the student who died, and their gross negligence resulted in those students' death. The prosecution's assertion that Ms. Crumbley owed a legal duty to the victims of the shooting is wrong as a matter of law. The question of whether a duty exists is for the court to decide as a matter of law. Duty is essentially a question of whether the relationship between the actor and the injured person gives rise to a legal obligation on the actor's part for the benefit of the injured person. In deciding whether Ms. Crumbley... Okay, so what they're saying here is that this is a legal duty, or a duty to do something, to protect somebody or to do something. That is determined by the court. It's a matter of law. It's decided as a matter of law. So it's not for the jury to speculate if there was a duty. It's for the court to say there either was or wasn't. The issue for the jury is whether or not there was a breach of that duty and whether or not the breach caused the injuries. So a duty is decided as a matter of law by the court. In deciding whether Ms. Crumbley owed a legal duty upon which to predicate liability for involuntary manslaughter, it is first necessary to determine whether her acts or omissions constituted misfeasance or nonfeasance. Michigan's courts have distinguished active misconduct causing personal injury, misfeasance, and passive, inactive, or failure to protect others from the harm, which is nonfeasance. Okay? So the theory here is on the nonfeasance. Based on the plain language of the charging document, the prosecutor's theory of liability against Ms. Crumbley is based on nonfeasance. So essentially, you had a duty to act and you were passive. You didn't act. Generally, with respect to nonfeasance, there is no legal duty that obligates a person to aid or protect another. Yeah, send me some bad checks. Can't bring peanut butter. You know what? This kind of goes hand in hand with a stream that Uncivil Law did the other day regarding a Supreme Court case out in New York. Well, it was a U.S. Supreme Court case, I believe, and it was a case from New York, and it was whether or not someone can be convicted of a violent crime when there was like actually no violence. And there was this whole thing about there's this whole line of questioning from the justices about poisoning, right? Is poisoning a violent act? And what is the actual act? Is it putting the poison in the substance? And it's like, okay, so let's say putting the poison in the substance is the violent part, even though it interacts with the body later. What if you know that there's a cake in the refrigerator that has gone bad, and you know whoever eats it is going to get sick, and you're like, go eat it, go eat it? Is that encouragement? Is that a violent act? Is that culpable at all? And it depends on if you know that it's poisonous. So bringing peanut butter to school just made me think of that. That was a great stream by the by Uncivil. I don't remember the case name. It was sometime this past week. You guys should all go check it out. Generally, with respect to nonfeasance, there is no legal duty that obligates a person to act to protect another. The only exception to this general rule is where there is a specific relationship existing between the persons. Now, the persons are the persons not acting and the person who is injured. An individual has no duty to protect another from the criminal acts of a third party in the absence of a special relationship between the defendant and the plaintiff, meaning the injured party, or the defendant and a third party. So there has to be a special relationship. The rationale underlying the general rule that absent a special relationship, a person has no legal duty to protect another from the criminal acts of a third party is rooted in the fact that criminal activity by its deviant nature is normally unforeseeable. I like the way that that is phrased in this case, and I'm going to remember this case, 1989. It's not that old. Well, it's an old case, but I mean, we cite cases sometimes that go back to the 1800s. Holding that under all ordinary and normal circumstances, in the absence of any reason to expect the contrary, the actor may reasonably proceed upon the assumption that others will obey the criminal law. Examples of specific relationship recognized under Michigan law include landlord-tenant, patron, propertier and patron, employee, employer, employee, residential, inviter and invitee, physician or psychiatrist patient, and doctor patient. So those are the ones that have been recognized under Michigan law. The Court of Appeals described the rationale behind imposing these legal duties. So we're talking about landlord-tenant situation, a store owner, employee-employer relationship. The rationale behind this is that in a special relationship, one person entrusts himself to the control and the protection of another. In a consequent loss of control to protect himself, a duty to protect is imposed upon the person in control because he is in the best position to provide a place of safety. Thus, the demonstration whether a duty imposes a special relationship exists in a particular case involves the determination of whether the plaintiff entrusted himself to the control and protection of the defendant with a consequent loss of control to protect himself. Okay. So what you'd have to say is that this 4 students that were shot placed themselves in a position that made Jennifer Crumbley the best option to protect them, essentially. Well, when it comes up with landlord-tenant situations, like let me give an example. You expect your apartment to be fairly safe and secure. So let's assume the locks don't work. The landlord could be responsible if somebody breaks in and murders you or rapes you or does something to you, right? The landlord could be responsible in that case because you're there, you're assuming that the doors are going to lock. They're in a position to actually make sure that the doors lock and that they fail to do it. Because through your agreement, you have placed each other in this position where the tenant is in a vulnerable position, asleep in their bed at night, and they have asked you to essentially take on the obligation of making sure the locks work. Based on these controlling precedences, Mrs. Crumbley owes no legal duty to the victims of the shooting. There are no facts from which to find that any of the victims entrusted themselves to the control and protection of Miss Crumbley. To the contrary, Miss Crumbley had no connection whatsoever with any of the victims. Good luck filing that claim if you're dead. Yeah, well. Basically total failure, just like the Crumbley defense team. Yeah, right. That's my goal. Okay, so I gotta tell you, I once had a job where I was doing facilities maintenance. It was basically like I was a glorified janitor, but they call it facilities. And we were asked to clean out a bunch of cabinets in the conference room. And there were like cases of Coke. And I was like, oh, I'll take these home. They're just gonna toss them. They were like 5 or 6 years old. And I was like, but it's free Coke, take some cans of Coke home. Cracked one open and it tasted like I was drinking metal. But you got to take your chances. You got to take your chances when there's free cake, free Coke, whatever it is. Finding, so then they cite a case, C. Murdoch, finding no special relationship between the injured party and the defendant, where the injured party never surrendered control of himself to the defendant. In the absence of any facts from which to find that Mrs. Crumbley owed a legal duty to the victims, there is no duty imposing a special relationship upon which to impose criminal liability. Now, the difference, like, say Jennifer was what do they call them? Like a school mom or whatever. She volunteered in the school. And she put herself in a position of authority. Now to some extent, she's created this sort of situation where it could be considered a special relationship. Like you would say that the special relationship would exist with the teachers, right? Maybe a school counselor, maybe there's a special relationship there. But not with Miss Crumbley. She didn't even know the victims. Nor can the courts conclude that Miss Crumbley owed a legal duty to the victims based on the facts that her son was the shooter. Michigan law is clear that family relationships in and of themselves do not give rise to a duty imposing a special relationship. Typically, the courts are reluctant to find family members liable for an adult assailant's actions when the liability is premised on negligent-based actions, which charge the family member with such things as failure to warn, from 1997. And then another case, reversing the trial court and holding the family relationship was insufficient to impose a duty on the defendant to protect the general public from his brother. So here's another case specifically on that issue. I think I might have even cited this case when I was doing my earlier breakdowns when the Crumbleys were first charged. We declined to hold that the marital relationship automatically imposes upon one spouse a legal obligation to protect a third person from the dangerous or negligent acts of the other. Could you imagine being criminally responsible for the crazy ass actions of your soon-to-be ex? I do a lot of family law, and I don't see people in their best rational thought process during these family law cases. In fact, family law and criminal law sometimes go hand in hand. Now, imagine a situation where you're going to be criminally responsible for the intentional wrongful acts of your soon-to-be ex-spouse. Shouldn't all of this have been brought up before on a motion to dismiss the charges? Well, some of them were, but like it said at the beginning of this section of the motion, the duty aspect was not brought up, just the causation. And I took issue with that to begin with. Well, it wasn't brought up in an appellate level. This case did go to the Court of Appeals on an interlocutory appeal regarding causation. This issue was argued at the district court level during the preliminary examination, And then there was a motion to quash the bind over, which addressed this very issue as well. But all the judges denied it and said, no, there's a duty here under this theory. And they cited this sort of outlier case, which involves a guy who had a loaded sawed-off shotgun in a closet, and then without a lock on it, and then locked two young kids, like 4 or 5, in the room with the closet, and in the closet was that loaded gun, and he locked them in there for like hours, and they got a hold of the gun, and one shot the other. I don't think they died, but he was criminally charged and convicted of involuntary manslaughter because he created this dangerous situation by locking the kids in the room with a loaded sawed-off shotgun, and that's how he was convicted. And that went to the Court of Appeals. I don't think it made it to the Supreme Court, just the Court of Appeals. And the Court of Appeals said, yeah, this is enough to convict this guy. So they used that case in justifying the charges against James and Jennifer Crumbley. Now, the decision to bind them over and the denial of the motion to quash was never directly appealed, not the way it's being addressed here. So when you say it should have, maybe not. I think when you're filing interlocutory appeals, you don't want to argue the whole case. You just kind of want to pick like your 1 or 2 best arguments because you have a whole trial coming up. So they picked what they thought was their 1 or 2 best arguments and ran with it. Doesn't mean that it can't be argued now. Yeah, well, that's what I always said too with the gang shooters. Parents of gang members in Detroit now are on the hook potentially. I think Crumbleys could have been charged with contributing to the delinquency of a minor. I think there was enough for that because they said they got him his gun, right? There could be enough for that, or even child neglect to some degree. But the problem is that both of those are misdemeanors. And the prosecutor wanted to make a statement and one of these felony convictions that put them away for almost for the rest of their lives. And so contributing to the delinquency of a minor and child neglect would have gotten them a year's worth of probation, maybe 2 years worth of, no, it would have been like 1 year of probation and that's it. They wouldn't have done any jail time. That wasn't going to be enough blood for the sacrificial Crumbleys in this case. Let's see if I'm missing another chat. Lefty. I don't know. I blame Salvador, Lefty, for being demonetized. I had too many clips up of him. And YouTube sent me a notice saying I don't have enough of my own original content, so I got demonetized. Aren't you? You're monetized, right? And Farrell's still monetized, and I keep losing mine. Did the kid die? I don't remember. It's not relevant for creating the duty, right? Whether the child dies or not, it's immaterial for creating that duty. Sal probably did it. I know he did it. Locking children inside. No, he didn't lock them. Okay. There's a bedroom. In that bedroom is a closet that doesn't have a lock on it. Okay. And in that closet was a sawed-off shotgun. And so he locked them in the bedroom because the bedroom had a lock on it. He locked them in the bedroom for like 2 hours and like took a nap on the couch or something. I don't know what he did. And while the kids were in the bedroom, with an unlocked closet containing a unsecured, loaded, sawed-off shotgun. That was that case. That was from early or late 90s, I think. You're not monetized. Okay, well, I feel better now. I'm very bad at I'm very bad at this whole streaming thing. Dave trolls Sal with clips. YouTube gets mad. Dave blames Sal. Yeah, no, that's exactly. Yeah. That's about the sum of it. Can't wait to hear your thoughts on Luigi tomorrow. Well, I'm glad you're all enjoying my stream. You know, to be honest, if I had time to stream more of just like me sitting here and smiling at you all, I'd probably still be monetized. I just don't. All right, where were we? So I wanted to read. So back up here. To the contrary, Miss Crumbley had no connection whatsoever with the victims, right? And then I put this guy's up, and then there's a footnote here, footnote 7, and down at the footnote it says the same cannot be said for the school officials who received the proffer agreements by the prosecution. This guy's thinking just like me. I like this. I like the way this is briefed up. This is an appellate brief, though, people. I will say this is an appellate brief. It's filed in the lower court, and it's filed to preserve the issues. The judge isn't going to have any of it. But this is a good appellate brief. This isn't all the issues that they're going to raise in the appeal, but this is a good start. Yeah, YouTube does not understand fun anymore. But I can say whatever the fuck I want now, and I don't have to worry about, monetization and is it safe for our advertisers. Ms. Crumbley was under no legal duty to control or prevent her son from committing intentional criminal acts, despite the fact that the law recognizes no legal duty between Ms. Crumbley and the victims of the shooting. The prosecution proceeded, nonetheless, on the theory that Ms. Crumbley had a duty to control her minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. Again, so much words. However, this duty, as instructed by the court, is derived from civil cases involving claims of negligent parent supervision. Again, we addressed this at a lot of the pretrial streams that I did. This is a civil thing. We're holding people criminally responsible for violation of civil standards. Think about that. Just think about that for a minute. We're going to lock people up in jail for 25, 30 years for violating a civil standard. I don't get YouTube. They make money to monetization. What's wrong with them? Again, that's what I was thinking. Actually, you know what? I think they make money even if I'm not monetized, because I bet you they're still running ads on this stream right now, even though I'm not monetized. I don't have, I have premium, and so I don't pay for the ads, but I bet you people will see ads on this stream. Can I start up a storage unit channel? You know what? I'm gonna start an auction site. I'm gonna start auctioning off my Legos. If you guys want to bid on some Legos, I'm going to sell it on Temu. No, wait, is it Temu? I don't know what the app is. Yes, yeah. You know what? That is true. That the monetization thing is so weird. That and like using songs, little clips. Like there was a Lego stream we had. By the way, guys, if you're new to this channel, there's a reason why so many people were asking about Legos, and I have so many Legos. I do have another channel, which is pinned in my description below. It's called Lego Law, Life, and Libation, where I interview people and build Lego at the same time, along with Valhalla Awaits and Wendy H, who you saw earlier in chat. And it's a good old time. It's just laid back fun, not so serious. But one of my channels got demonetized. Not demonetized. It got monetized claimed because I played 30 seconds of a song that I didn't own the rights to. So like all the money from that went to whoever created that song for the 30 seconds that it was played. Let's see here. In fact, this duty-based language is set forth in Restatement Second of Torts. Yeah, I think we even pulled that up too. It's a torts thing. And so torts are like intentional wrongful acts or negligence. All right, so I'll give you this case, and many of you have probably heard it already, but it's taught in law school, and it's talking about proximate causation. Now, I'm going to describe the scenario, and you tell me who is criminally responsible. Criminally, not civilly. Not like, oh, we're going to pay damages to make you whole again. It's criminal. Who's going to jail? So a guy is running late for the train. He enters the train station with a box under his arm. The train has already started to leave the station, but the ticket taker lets the guy through the chase after the train. So he's running down after the train. He's running on the tracks after the train. Now the conductor on the last train offers his hand in assistance and gets the guy up. But in the process, the guy drops his box. Now the box contains fireworks. Nobody knows it contains fireworks, but it contains fireworks. And the box fireworks goes off. One of the rockets shoots back into the train station, hits a sign on the wall, knocks the sign loose. That falls on a lady's head, and the lady is injured. She's not dead. She's just injured, but like pretty bad. So who's criminally responsible? Who's going to jail? Because that's the standard that we're talking about here. All of them. Yeah, Mavica. Yeah, I would expect you to say that. All of them. So in fact, nobody was responsible civilly because it wasn't foreseeable. And it's talking about for approximate causation. Like, yes, letting the ticket taker letting the guy through obviously caused the woman's injuries, but for that, she wouldn't have been injured. But is it foreseeable? Is it really foreseeable that would have happened, all this chain of events? So, but when we're talking about these civil standards, applying them to criminal cases, who's going to jail? Who should be going to jail? Dave is responsible. It's always me. Relying on American states insurance company. Oh, it's a case. I was trying to figure out what that was. The Court of Appeals in Estate v. Goodwin again addressed the duty of parent to supervise or control their minor child to see that the child behavior does not involve danger to the child. Yeah, it does not involve danger to the child. That's different. Involved the claim brought by a mother whose 6-year-old son was hit and killed by a car on defendant's fairground property. The defendant sought to name the defendant child's father as a non-party at fault, which the trial court denied. The jury ultimately returned a verdict in favor of the child's estate, and the defendant appealed. The Court of Appeals reversed the jury verdict and faulted the trial court for striking the defendant's notice of non-party at fault, naming the father as an additional negligent party. In reversing the lower courts, the Court of Appeals reasoned that a parent cannot allow their children too young to understand danger to wander unattended. Rather, parents, as persons with special dealings with their children, are expected to provide care and protection, but that's to their child. In expounding on this parental duty, the Goodwin Court went on to hold that parents are expected to exercise reasonable care to control their minor children. And that was the case that the prosecutor argued. I remember that. And to provide instructions and education to ensure that the child is aware of the danger to his or her well-being. Viewed in the context of these authorities, it is abundantly clear that the parental duty to control their minor child has been applied only to circumstances in which the child was unable to appreciate the risk and or dangers of his actions or environment, right? But yet at the same time, you're charging this child as an adult, sentencing him to life in prison because he knew what he was doing was wrong and planned it for months. Such duty has never been applied to circumstances involving teenagers who commit intentional criminal acts. This is said so much better than I've been yelling at the screen about, but it's exactly what I've been saying. This is the problem. You have the intentional wrongful acts of a third party who is able to control and appreciate the wrongful acts and the dangerousness of their actions. Because Ms. Crumbley was under no legal duty to control her minor child, she cannot be held criminally responsible under Michigan involuntary manslaughter statute. Okay, I have 12 pages left. I think I'm not going to call it for today. What I'm going to do is set up a stream for tomorrow. Probably tomorrow early. My I said earlier, my throat's been hurting a little bit, and I can hear it. I don't know if you guys can hear it at all. It's getting a little scratchier. Thus, old 5-year-old cola might not be a good idea. Yeah, right. So, but that actually, it goes into the same argument with regard to the guy who locked the kids in the bedroom that contained a sawed-off shotgun that was fully loaded. They were young. They were like 4 and 5 or 5 and 6, right? So are they in a position to appreciate the risks and or the dangers involved in their actions or their environment? Probably not. But Ethan Crumbley, on the other hand, sorry, I just wanted to highlight this, right? This is the standard. Are they able to appreciate the risk and or the dangers of his actions or environment, right? A 5-year-old, probably not. Ethan Crumbley at 15, was he 15, 16, 15? He can appreciate it. He planned it. He wrote it out. He in his journals, he knew what he was doing. I got fired. I didn't quit. Yeah, that's right. Where's my severance? When's the next stream? Stray, I'm going to set it up for tomorrow. I don't have it set up yet. I'm actually using a new streaming platform that Nick Staroff turned me on to. So I've got to go through and set that up for tomorrow. I'm going to see who else is streaming. I don't want to stream on top of anybody, and I don't want to make it complicated and confusing for everyone. So I'm going to see who's set up for tomorrow. Maybe I'll go like 2 hours before Excited's Sunday stream. She does hearsay for days, and then I can redirect you guys all over to her. Who's streaming right now, by the way? Who is streaming? Who do we want to send you all to? What do we got? Oh, you know what? I'm going to send you guys over to Sean. I will redirect you guys over to Sean. Let him know I said hi. If you guys don't know Sean, potentially criminal, he is... why can't I... Oh, hang on. I got to actually get to my live stream. I was on an old Crumbley stream. There we go. So say hi to him. I don't know what he's talking about tonight, but I'll redirect you guys over there. I just want to get this set up, and then I'll get back to the chat. Okay, now we're all set up. What the hail stream? Oh, I should redirect. Wait, why is he streaming? What does he have to talk about? There's nothing going on. I'll send you guys over to Sean. Yeah. Same time lawyer in a small town in central. Wait, small time lawyer in a small time in central. What? I don't know what you're trying to say. In a small time, in a small town, potentially criminal. You're talking about potentially criminal. Yeah, he's a criminal / civil. He kind of does the same stuff that I do. I think he does a lot more criminal than I do, but he also streams. He has a channel. He's from Ohio. We don't hold it against him. Yeah, I think I figured it out. Yeah, it's been a long day. But welcome all who are new coming over from Dolly Talk. Beautiful waterfall. And I can't remember who else said that they were new coming over, but glad you guys are here. Hope you enjoyed it. And I'll post something up again very shortly. Tomorrow. I'll be streaming tomorrow at some point. Yeah, I know. I got that. We figured it out, Ilya. We figured it out. Now, what I need to know is what time Excited is streaming tomorrow so that I can set up for 2 hours ahead of time. You know what's funny is the last time that YouTube said that I wasn't streaming my original content, I started streaming like random stuff, and I got monetized. But it was like a fan blade going on, or me just hanging out. Hey, Jamie, I didn't even know you knew what this channel was. But welcome. I'm streaming tomorrow. I'll be back tomorrow, everybody. Tomorrow at sometime o'clock, probably in the early afternoon. I will be back here. We will finish this up. We're going to go. So just, you know, we have the rest of this, and then we have this whole civil thing that we need to go through. So we have a lot to go through. So it'll be another couple hours stream tomorrow. And I will see you all then.
When I was young, my daddy said, gotta keep one eye open in your bed. Cause there's a time coming when the devil gonna come for you. So my trigger fingers say prepare. I've got my weapon and I got my prayers. Cause if you don't run this town.
What am I waiting for? Okay, I waited. Ilya, what's going on? Shit. All right, you know what? Screw you.
When I was young, my daddy said